So we will discuss some latest cases, what decisions were given, and some related laws on the facts of that case. Okay, so there are 3 cases. All these cases are of Supreme Court of India. Decisions came in the year 2021 only. Okay, so we will be seeing what these cases are all about. First one that we have, it was decided on 21st of October 2021. I will share my screen 1 second. Okay, so it was decided in 21st of October 2021. Sometimes when we discuss a case, okay, you will see, take for example, it would apply even if you are reading a case from a book or some article or somewhere. Okay, so when you are reading some cases, sometimes you will get these kind of citation. Okay, equivalent citation. There are 2 citations, either one you can refer, and sometimes this part will not be available. You will simply get this date. Okay, one date will be mentioned when the case was decided. So what is the difference between these 2 things? Anyone? Why is it that for some cases we get a citation? For some cases, we don't get it. We just get this date when the decision came. Not same case, different cases. Okay, like this one, AK Gopalan case, you are getting the citation. But this one that I'm mentioning, here, there is no citation. There is just a date, decision date. So why is that difference? Okay, maybe because no other case was decided on 21st of October. Anyone else? But what is this date all about? I think I mentioned in the first class also for this decisions part. What is this date all about? What it indicates? Citation that is provided. Publication, correct. So if it indicates publication, for some cases, you get this citation. For some cases, you don't get it. That means these cases were published in some reporter, and for the ones where you don't get it, it is not yet published. Why? Because these are latest decisions that we are reading here, right? Correct. It is the publication thing that we get, right? In which reporter, in which year, in which volume, in which page number it was published, we get that detail. And for these latest cases, because they are yet to be published, it was only 21st of October the decision came, so you don't get the citation. So this case is Prem Shankar Prasad versus State of Bihar. It is also called as proclaimed offender case. Okay, offender as in someone who has committed an offense or a crime. Proclaimed as in it has been, like it has been established or it has been published somewhere. Okay, it has been proclaimed by the court that this person is an offender. Proclaimed offender case, Prem Shankar Prasad versus State of Bihar, decided in 2021 by Supreme Court of India. Now, in this case, if you see, parties are Prem Shankar Prasad versus State of Bihar. So he is the appellant. Okay, this case, when it was filed before Supreme Court of India, it was filed as an appeal, right? Criminal appeal. This is the number which we have. So this case was filed as a criminal appeal before the Supreme Court of India, and Prem Shankar Prasad is the appellant in this case. He filed the appeal because he was not satisfied with the decision of High Court. or the decision of trial court. Plus, there is no limitation as such, right? How many petitioners or how many respondents can be there in a case? Same ways, there were more than one respondents. First one is state of Bihar. Respondent number 2 is important, who is Rajneesh Kumar Srivastava. Okay, Rajneesh Kumar Srivastava is the respondent number 2. Usually when you read a case from here, right, it's different if you are looking at the reporter or something, but here usually you would get like appellants, respondents. That means there were more than one appellant, there were more than one respondent, but names of all the respondents might not be provided in each case. Okay, and if you still want to know who is the respondent in this, who were the other respondents and all that stuff, right, you can go to this one. See, this is an appeal. Okay, this case is an appeal. Why appeal was filed? Because they were not satisfied with the High Court's decision. So what is the High Court case number? You can go there. It is High Court of Patna, and this is the case number. So you can open High Court of Patna website. There you can add this case name, case number, and then year, and you will get the details of High Court case also. There you would likely find the respondents' names. Okay, from where I got this name, Rajneesh Kumar Srivastava, it's not mentioned over here in the Supreme Court case. Okay, so if you are doing like a detailed study on some case, you can use that way to get the details. All right, so everywhere it would be mentioned while you are going to High Court website. There also trial court's detail will be mentioned. Like that, you can get the details. So mainly here, this is the appellant and this is the respondent who are important. And this case was decided by a divisional bench. Mostly for criminal appeals, it goes before a divisional bench only. Same happened here as well. Now, the respondent, okay, that is Rajneesh Kumar Srivastava, had to give an amount to Prem Sankar Prasad. Okay, this is a case relating to some commercial transaction. Okay, so this respondent number 2, Rajneesh, had to give some amount to Prem. And this amount, out of this total amount, right, they made an agreement that, okay, fine, one portion I will be paying you in cash, another portion I will give you a check for that. All right, so based on the agreement that they both came to, they said that, okay, fine, 36 lakhs I'm giving you in cash. Rajneesh said to Prem that 36 lakhs I'm giving you in cash, and this remaining 10 lakhs, which I'm supposed to pay, I will give you a check for that. Okay, this was done. But this check was dishonored. For dishonor of check, we have a legislation. Anyone aware of this legislation? Check bounce case, under which legislation can we file? There is one legislation called Negotiable Instruments Act. There are two sections, 138 and 142. Okay, so cases are filed under these two sections. 138 basically talks about dishonor of check. 142 is cognizance by magistrate. So under this, the cases usually filed of Negotiable Instruments Act. Now this legislation, Negotiable Instruments Act, it mentions when will it be considered as check bounce. It is if I have issued a check of 10 lakhs rupees, but I'm not even having 10 lakhs rupees in my bank account. So the check will be dishonored. In that case, it will be check bounce. Or if there is like signature, some wrong signature I have put, or I have asked the bank that do not release this check and stuff, in such cases, it will be considered as check bounce. But there may be other situations. Okay, take for example, there is a validity of checks, right? What is the validity of a check? once it is issued, within what duration can we claim the money? Can we demand the money? Anyone? Validity period of a check.
Is 6 months.
It used to be 6 months at one time. At present, it is 3 months. Okay. And usually in the check, it will be mentioned also. This is valid for 3 months, like that it will be mentioned. So if this 10 lakhs rupees for this amount check was given and he was too lazy to submit it in the bank and 3 months got over, after that he is submitting and the check is dishonored, in that case it is not a check bounce case under section 138. Okay, so it will be a check bounce case only if there was insufficiency of funds, the person ordered bank not to release the amount, or the person has already, like previously some arrangements the person has made with the bank that you should not be releasing more than 1 lakh rupees in terms of check. That kind of some arrangements might be there. In such cases, it will be called as a check bounce, right? Case of check bounce under section 138 and 142 of Negotiable Instruments Act. This is a very common section. Okay, and this legislation is a very common legislation where most of the cases are filed. Like if you take the example of any company, any organization, you will be able to find at least 1 or 2 check bounce cases, if not any other case. Okay, it's that common because a lot of times transactions happen through check, and if it is dishonored, then parties would file the case as well. Okay, so it is section 138. Now it says what is dishonor of check and everything, plus it also mentions the punishment that may be given. What is the punishment now? Punishment is imprisonment for a term which may extend to 2 years, or with fine which may extend to twice the amount of check. Okay, so this is very important. Twice the amount of check may be given as fine, and also imprisonment up to 2 years. This is the punishment. Now, that punishment is not that severe also, right? It's just 2 years of imprisonment. But when a check bounce, like there is dishonor of check, right? There are certain other provisions of Indian Penal Code as well, which are also like cases filed based on those sections as well. Okay, so same thing happened here as well. Now, this person gave 36 lakhs in cash, and for 10 lakhs rupees, he gave a check that was dishonored because of insufficiency of funds. After that, what happened is Prem Shankar Prasad filed an FIR against respondent number 2 in Chapra police station, and these were the sections under which he had filed. Okay, so the case was filed under all these sections as well, section 406, 407, 468 and 506 of IPC. Now, Indian Penal Code, if you look at the legislation, it provides for definition of different crimes. It provides for punishment. Okay, but now when the situation actually takes place, we need to know the details on how should we be approaching the court, right? So where do we get the details, like the procedural part, the process, how to approach the court, which court to go? Yes, we get it in CrPC, right? So if you open the Bare Act of CrPC, okay, CrPC Bare Act, there all the detailed process and everything is given. And if you open here first schedule, okay, schedule is nothing but additional information, some extra information, right? So here if you open first schedule, it provides for offenses under IPC, whatever offenses are provided under IPC, right? For all those offenses, it provides for this detailed list which mentions the section, under which section of IPC that offense has been given, what offense is it, what is the punishment, plus which court will have right jurisdiction, which court should we be approaching, that is also mentioned. Along with that, it says cognizable and non-cognizable, bailable and non-bailable. Whether this particular offense is cognizable or not, is it bailable or not. All these details are mentioned very clearly in CrPC. Okay, so what is cognizable and non-cognizable, anyone? And what is bailable and non-bailable? Arrest warrant not needed in cognizable, correct. In case of cognizable, arrest warrant is not needed. Police officer can directly arrest. In case of non-cognizable, police officer needs to wait for the warrant. Bailable means you can give bail because it is that much serious. Non-bailable means you cannot have bail. Not like you cannot have bail, but yeah, if there are valid enough reasons, court may provide you bail. In case of bailable offenses, bail is like your right, you can claim for it. Okay, in case of non-bailable offenses, court would look at the situation, all the other things would be considered. After that, court will decide whether to give bail or not. So that details is being provided. Now, same thing, if we look for these sections, 406, it talks about criminal breach of trust. Okay, criminal breach of trust is punishable with 3 years of imprisonment. Here it is a bit severe one, 7 years of punishment. Forgery for the purpose of cheating, 7 years. And 506, criminal intimidation, 2 years of imprisonment. Okay, so these are the punishments and everything mentioned, plus these are cognizable, non-bailable. So this one is non-cognizable and these are non-bailable. Okay, so that is what all these sections were also mentioned while filing the case. So FIR was filed against this person because check was dishonored. Now, because these were non-cognizable offenses, right? There were non-cognizable offenses as well. Chief Judicial Magistrate issued a warrant, because without warrant, person cannot be arrested. So arrest warrant was issued. After that, what happened is this respondent number 2, right? Respondent number 2 started to abscond. He was concealing himself to avoid service of warrant of arrest. So he was trying to escape from this entire situation. Thereafter, Chief Judicial Magistrate issued proclamation against respondent number 2 under section 82 of CrPC. Proclamation basically means, you must have seen it also somewhere, formally court to declare that so and so person is having this FIR launched against this person, so he should present himself before this court or before this police station on so and so date at so and so time. Okay, time and date will be mentioned and the person would be formally informed that you need to present yourself over here. Okay, so this person was concealing for all this while, and once proclamation was issued, usually it would be published in some newspaper, sometimes it may be pasted in the house of that person, like the residential house of the person, or maybe in the court or somewhere like that. So here also proclamation was issued, and after issuance of proclamation, what this person did is the accused filed anticipatory bail application. Okay, he filed anticipatory bail application before the trial court. So what is an anticipatory bail application? It is usually filed before this case starts, right? It is usually filed when the person apprehends that I may be arrested, right? Maybe when FIR is lodged or even before that. But in this case, only after issuance of proclamation, where the person was already informed that you need to present yourself on so and so date at this place, After that only he applied for anticipatory bail application. So what happened is trial court dismissed this anticipatory bail application and rejected the prayer for the anticipatory bail on merits, as well as on the ground that as the accused is absconding and even the proceeding under section 82 and 83 have been issued, right? The person was issued proclamation, the person was absconding for all this while, right? So the accused is not entitled to anticipatory bail because he has shown his intentions, right? He was hiding for all this time. So it definitely does not make sense to issue anticipatory bail as per the trial court. And his application was dismissed. His application was not accepted, basically. After that, what happened is the accused was not satisfied with this order of high court and he approached the order of trial court and he approached the high court by filing this application. And high court, right, process that's since the process of proclamation have been issued, the accused should not be allowed the privilege of anticipatory bail. Ignoring the aforesaid relevant aspect, by impound judgment, high court has allowed the said anticipatory bail. Ignoring all of these other situations that the person was absconding for all this while, proclamation was issued, even after that only he applied for anticipatory bail. Before filing of FIR. Even after filing of FIR, people do it, like at the stage when you feel like someone may arrest you. Okay, usually person will commit some crime, or he would know that, okay, fine, maybe these people are thinking that I have committed this crime, let me apply for anticipatory bail. It's usually like at the very initial stage when the person feels that he may be arrested. So mostly at the stage of FIR time only, it is being filed by the person. So High Court allowed for anticipatory bail, trial court had rejected it, right? But High Court allowed for anticipatory bail, ignoring all of these situations. By observing that in the event of his arrest or surrender within 6 weeks in the court below, he may be released on bail on furnishing bail bond of 10,000 rupees with 2 sureties of like amount each to the satisfaction of Chief Judicial Magistrate. So basically, time was given that within 6 weeks from this order, within 6 weeks, if he is surrendering or he is being arrested, then he can be released on bail, and he needs to provide 10,000 rupees with 2 sureties giving same amount of money, and he was allowed, right? This anticipatory bail application was allowed. Now, with this order, right, it was not a satisfactory order granting anticipatory bail. So the original informant or the complainant, who is Prem Shankar Prasad, right, who was supposed to get this 10 lakhs rupees, Prem Shankar Prasad was not happy with the decision given by High Court of Patna, because Rajneesh Kumar was allowed anticipatory bail, that he can deposit this bail bond amount and then he will be released. So the appellant or this original complainant, he was not happy and he approached the Supreme Court and he filed this appeal, which we have seen. Like you would see even the number as well. Right, this is the criminal appeal number. This was filed in the year 2021. It is submitted that High Court has rightly observed that nature of acquisition is arising out of business transaction, right? Even though there were sections of IPC which were also added, like 406, 420 and all that stuff, it mainly is a conflict which is arising out of a business transaction, right? So merely because the check was given and the same was dishonored, it's not like every single situation it would be a case of cheating. Okay, it's not like it would be a case of cheating or criminal breach of trust. Sometimes it might also be that genuinely something might have happened as well, right? So because it was arising out of a business transaction, and just because it's a check bounce case, in every single matter 406 and 420 might not be applicable, might not be relevant also. So mostly it should be a case falling under section 138 of Negotiable Instruments Act. And also after investigation, a charge sheet has been filed, and in the charge sheet these sections were also being mentioned. Okay, because the person was absconding, because the person, even after serving notice that check is dishonored, the person did not make the payment for it, right? So these sections were also added. So Supreme Court also was of the view that whatever decision High Court has passed, that decision is not proper, because what happens is in this charge sheet, right, 406 and 420 is also being mentioned, and it is filed after investigation only, right? He is a proclaimed offender. Proclamation has been issued. Even after that he was trying to abscond. Before that also he was trying to hide, and he was not presenting himself, right? So considering all those situations, whatever order has been passed by the High Court, that order is not proper order, right? So Supreme Court, what it did is it quashed the order which was passed by the High Court. It said this order is not going to be valid. Yeah, to be certified. It basically not like a writ petition which was filed, it was a criminal appeal. Okay, writ petition would be where your fundamental rights are violated, there you are doing it. Okay, there might be many other situations wherein court is having the power to quash an order, an FIR, a complaint, etc. Okay, in every single case it might not be certiorari, but yeah, in case of violation of fundamental rights, it will be. You are correct in that sense, but this was just a criminal appeal. Okay, and even you would see this for high courts also, right? There is one section 482 of CRPC. A lot of times what happens is someone might file like a false uh, FIR against a person, a false complaint may be filed. In such cases, person would approach the High Court and say that this FIR is not proper or valid. Okay, so quashing of FIR, that is also very common section and very common type of cases which are filed. So in every single matter, it might not be certiorari also. Okay, it may be different as well. So in this certain case, Supreme Court also agreed that yes, whatever High Court has passed, whatever order High Court has passed, that is not proper. So this granting of anticipatory bail to respondent number 2, it is not proper, so it was quashed. However, 2 weeks from the date of pronouncement of this judgment, that means when Supreme Court pronounced this judgment, as in 21st of October 2021, from this date, within 2 weeks time, okay, is granted, respondent number 2 should surrender before the concerned trial court, and after that, okay, so again he was ordered that you need to surrender yourself because your anticipatory bail is no more valid. You need to surrender yourself before the trial court, and thereafter it will be open for respondent number 2 to pray for regular bail. Okay, because the case has already started, everything happened, he tried to escape and all that stuff happened, right? So anticipatory bail does not make sense at this stage, but he has a right to apply for regular bail, and which may be considered in accordance with the law and its own merits. The present appeal is accordingly allowed in aforesaid terms. That means anticipatory bail does not make sense in this case, but regular bail may be applied by this person, and considering all the situations, everything that has happened, it is upon the trial court to decide whether we can release this person on bail or it will be risky. Okay, that can be decided, and accordingly situation will be taken, because there is 506 also, right? Criminal intimidation. Maybe he was trying to intimidate the witnesses, victim, and stuff like that. So in such cases, it does not make sense to release the person based on anticipatory bail. Okay, is this part clear? In your free time, right, you can open this link. You can open this link, which is of CRPC first schedule, and you can go through this. Okay, you might find it interesting that all the offenses are being mentioned, punishments are being mentioned, which court we should be going, whether it is cognizable, bailable, and what kind of offense, everything is given there. Okay, so this is the first case we had, proclaimed offender case, Prem Sankar Prasad versus State of Bihar of 2021, 21st October. Next case is reversal of acquittal. So what is acquittal? Finding someone not guilty, correct. So when a case is filed, when this, released. When a case is filed, when this entire trial process goes, it may be that the person is released, person is acquitted, or it may be the person is convicted. Sometimes, it may be that, okay, fine, person is released, but based on benefit of doubt. Those kind of situations also may take place, but ideally, it may be person is acquitted or person is convicted. Okay, now when we say reversal, as in reversing this order of acquittal. Okay, first of all, court said that this person is acquitted. This person has not done any wrong. His guilt is not being proved. He is released. After that, that same order is reversed. Reversal of acquittal. Okay, this case is all about that. So person was released. Again, he was considered that no, he has committed the crime. So the case is Suman Chandra versus CBI. It was again decided in 2020. All right. So what happened in this case? Again, there were, it was a division bench, 2 judges were there. Now, in this case, what happened is, trial court passed a judgment in the year 2006, whereby the appellant has been acquitted. Appellant as in Suman Chandra was acquitted. Trial court found that he is not guilty. His guilt is not being proved. So he was acquitted by trial court. But after that, High Court of Calcutta, in the year 2017, what they did is, they reversed the judgment of trial court. They completely changed the judgment of trial court. It was not like changing the punishment, that okay, fine, person was convicted only, but here and there are some changes in the punishment given. Maybe it was reduced, maybe it was increased, not like that, but the judgment itself was reversed, which was given by trial court, and convicted the appellant, was given punishment with imprisonment for a term of 1 year and fine of up to 5,000 rupees for the offense, which was punishable under Prevention of Corruption Act. So High Court of Calcutta found that no, this person is guilty. High Court of Calcutta convicted this person and gave this punishment of 1 year of imprisonment and 5,000 rupees fine under Prevention of Corruption Act. The trial court has given a detailed judgment, okay, giving several reasons for acquitting the accused. What were the points based on which he was accused? What were the points based on which it was like proof that the person has not committed the crime, right? All those reasons were also given. Like in India, we have a concept of natural justice. Okay, there are some concepts based on it. It says that like when a case is being filed, okay, when a case is filed in the court, both the sides of the case should be heard. It does not matter how well established the case is already, both the sides should be given the chance to speak. Okay, that's why you must be remembering this Kasaf case, right? Bombay Taj Hotel attack. It was like well established, right, that he is the one who attacked, but he was also kept in prison. Entire trial process went on for him. So much of money government had to spend in like ensuring his safety and other stuff. Why? Because we want to follow this, that both these sides should be heard. Plus, no one should judge his own case. If there is a dispute between you and me, and I am the one who is to give a decision, I am the judge in that dispute, obviously I will give a decision which will be biased towards me, right? I will think about my own side, but not yours. That is why another principle is no one should judge his own case. It has to be some neutral, unbiased person. And last one in this is reasoned decision. Fine, judges are highly qualified, trained people, but they cannot simply say that, okay, fine, this is the judgment, take it. Even while giving a decision, judges need to provide justifications. Okay, they need to justify that because of this, because of that, because of this precedent, because of that law, this is the final decision that we are giving. That means judges also need to provide reasons. Judges also need to justify why they have given that certain decision. Okay, these three things are very important for ensuring justice. Okay, now in this case, what happened? In this case, while trial court acquitted this person, trial court gave lot of reasons as well. Whereas when High Court reversed this order, High Court subsumed its own view. High Court did not provide their own, like this justifications or reasons were not proper. Usually what happens is, because we follow this concept of precedent, right? A lot of precedents will be mentioned. Okay, what is precedent? Who remembers? Concept of precedent. What is a precedent? A case which is used as an example. Yes, correct. A case which is used as an example to help guide future judgments. That means while providing this reasons for the decision, right, a lot of precedents, a lot of previous decisions will be mentioned for similar cases. Correct. For similar cases, if same sort of situation had happened, those references will be given, that in so and so case this is how it happened, in so and so case this was held, so we are also taking this decision. But in terms of High Court, they did not provide any such satisfactory explanation and stuff. They simply just changed the judgment, okay, reversed it. So it is well settled that reversal of acquittal is permitted. It's not like we cannot reverse it. Reversal is permitted. but there has to be some valid enough reasons. Like if the decision was erroneous, it was unreasonable, it was perverse, in such cases it can be allowed, but not like in every single case. Okay, so it has to be also established that the decision of trial court was any of these. Okay, but that could not be proved. So the view taken by trial court was a possible view which was neither perverse, neither unreasonable, and the facts and circumstances of this present case ought not to have been reversed. So whatever decision trial court gave, it was not falling under any of these grounds, plus High Court also could not prove any of these grounds. So in such cases, it should not have been reversed by the Calcutta High Court. So Supreme Court accordingly mentioned that this reversal order, right, which High Court has mentioned, that is not proper. So we will set aside the order of High Court of Calcutta and we will restore the judgment which was given by trial court. Okay, so in this case, what happened? Suman Chandra versus CBI, reversal of acquittal. First of all, in trial court, the person was acquitted that he has not committed a crime or his crime could not be proved. But then later on, High Court said that no, the person is guilty and he was given punishment as well of 1 year of imprisonment or 5,000 rupees fine. But then at the stage of appeal before Supreme Court said that High Court's order is not making much sense. We will set this order aside and also we will restore the judgment of trial court. Again, that acquittal order only will be valid in this case. Okay, so this order of trial court was again restored and High Court was set aside. Is it clear? Okay. The same sort of situation happened in this Nanavati case also.
This was a culpable homicide case, right?
Which one?
This one?
It was actually...
They made a movie on this.
Yeah, Rustam, right?
Rustam.
It was proved to be murder only because culpable homicide could not be proved. Like there was no sort of, like quarrel or any sort of arguments between them could not be proved. So later on, he was given punishment for murder only. Right? So this case is also similar where reversal of order passed by Sessions Court by High Court of Bombay, but in this case it was approved by Supreme Court of India. Right? Sessions Court at that time jury used to be there and jury got like a little bit emotionally attached to that case and they just said that no, he is not guilty, but High Court said that no, this is not proper, right? This is like erroneous. It is well established case. So High Court reversed this order. And then at the stage of appeal, Supreme Court also said that yes, correct. High Court is correct. This only has to be there. So accordingly, punishment was also given. So basically, the court had to decide whether it is like murder or is it culpable homicide, right? So this is Nanavati case. Basically, there was murder, punishment for murder, and also culpable homicide not amounting to murder, right? This naval officer, he killed or he murdered his wife's lover, Prem Ahuja, and then in the trial court, basically Bombay Sessions Court, the jury said that no, he is not guilty. But then case went to Bombay High Court and Bombay High Court said that no, this is not proper, but he has, committed the wrong basically. Section 304 is culpable homicide not amounting to murder, where it's like, yeah, you have killed the person, but it was not like pre-planned and all those things were not there. It might be because of a sudden quarrel okay, you lost control and you just killed another person, or maybe two people were fighting and something happened, another person died, or it may be that because of use of the self-defense, right of self-defense. So many grounds are there. Because of any of those reasons person is killed, it's not like pre-planned and stuff. Okay, so this section was also added over here. Yeah, finally it was like it's not culpable homicide, but it is murder only. You can watch that movie as well, Rustam, where also the same grounds were mentioned, that Prem Ahuja, at the time when he was killed, right, it happened in his bedroom, so he was wearing just a towel. So there was no, like no sign that okay, both those two people were fighting or something. He just died normally. Okay, so based on all those grounds, it was proved that no, the situation and all those things, it does not prove that Prem Ahuja and Nanavati were fighting or having some quarrel or stuff, but it's like he went there and he just killed Prem Ahuja. So he was punished under section 302 only, murder. Okay, so this main thing was what has to be decided. Punishments would also vary and accordingly. So he was given punishment, but later on, as we know, right, governors or president would have the power to make changes in the punishment, right? If someone is given life imprisonment, there may be that punishment may be reduced or it may be changed to a less severe punishment, like that happens. So he just served for, I think, 3 years of punishment. After that, he was released by an order of governor, and then they moved to, I think, London, and then they settled there, they lived there happily. So that was another case wherein Supreme Court approved High Court's reversal order because this judgment was erroneous. But in this present case, okay, they moved to Canada. Okay, correct. So this happened over there. Okay. Now, one more case which we have is related to attempt to murder. Okay, not murder, but attempt to murder. Sadakat Kotwal versus State of Jharkhand. Again, a recent case of 12 November 2021. Now, what happened in this case? Same again, okay, all these three are like criminal appeals decided by a divisional bench of Supreme Court of India. Now, in this case, Sadakat Kotwal caused injury to a victim with a dagger, okay, in her ribs. And it was a case of single injury, okay, only once he just injured the victim and it happened. Now, the appellant, that is Sadakat Kotwal, the appellant, he was convicted under section 307 of Indian Penal Code by the trial court. When this matter was filed before trial court said that this person is convicted. He has attempted to murder the victim. Okay, he has attempted because it was just one injury. The victim somehow survived, but he did attempt to kill the victim. That was what trial court said. Now, for attempt to murder, punishment is severe. Okay, if otherwise it's like 10 years or shall be liable to fine. In case hurt is caused, then it may go up to imprisonment for life or 10 years or fine or something. That means for attempt to murder, the punishment is much severe. Now, feeling aggrieved and dissatisfied with this judgment, which was passed by High Court of Ranchi, criminal appeal was filed in which High Court has upheld the convictions. Okay, High Court also said that no, whatever trial court said that you are guilty under section 307 of IPC, that is actually true. You have actually attempted to kill the victim, so you are held liable under that. Now, this person, right, Sadakat Kotwal, he was of the view that okay, fine, I used this dagger, I caused injury to the person, but then I should not be held guilty under section 307. There is one more section in IPC, Okay, that is section 323, which is punishment for voluntarily causing hurt. And here punishment is very less, which is just 1 year of imprisonment or fine, which may extend to 1,000 rupees or with both. So even if both the punishments are also given, it's just 1,000 rupees fine and 1 year of imprisonment. It's like too less, right? So he said that, fine, I have caused the injury, but I should be held liable under section 323 and I should not be held liable under section 307. I have not attempted to kill the victim. I just voluntarily caused hurt to the victim with the dagger that I was using. So in this present case, the injury of a single blow was on the vital part of the body, right? When injury is being caused, in which part of the body is it caused, right? Because there are certain parts of the body where if injury is caused, there is more likelihood that the person would die, right? So in such cases, it has to be considered that in which part of the body was it caused. Was it a vital part where if injury is caused, there is like more possibility that the person would die. So in this given case, it was stomach and near chest, which part was targeted by this person, right? Sadakat Kotwar, he targeted stomach and near chest area of the victim, where he injured the person with a dagger once. Now, nature of the injury is a grievous injury caused by sharp cutting weapon, right? It's not like like a stick or something was used, but it was a sharp cutting weapon, and this injury was also very much severe injury. The blow given to him was so imminently dangerous that it must, in all probability, cause death or such bodily injury as is likely to cause death. It was very serious injury which was caused. It was caused with a sharp cutting weapon, plus it targeted a vital part of the body of the person as well. Okay. So this incident is also not because of a sudden quarrel or any other, like it's not because of heat of the moment, but it was like all well planned and everything. Thus, deadly weapon has been used and injuries are found to be grievous in nature. So, because these like deadly weapons were used in such a vital part of the body, the person is rightly convicted for the offense of 307. That means, because considering all these situations, that it was not because of a sudden quarrel, it was not because of heat of the moment, it was all well planned. With a sharp cutting weapon, he targeted vital part of the body of this person, where there is all the possibilities that the person would have died, right? So considering all that situations, the person is rightly convicted for the offense of section 307, wherein punishment is much severe as compared to section 323, where punishment is like almost like nothing, right? 1 year of imprisonment and 1,000 rupees fine or with both. Now, like you must be remembering, right, that in IPC we discussed there are some stages of committing a crime. There were 4 stages. Who remembers stages for commission of a crime? Planning. Okay. Okay. So it is intention, preparation, attempt, and then finally accomplishment or the crime. Okay, first of all, we will have the intention. Secondly, In order to fulfill our intention, we will plan, we will prepare. After all the planning, all the preparation is being done, we will attempt. And once we make the attempt, it may either be successful or not. If our attempt was successful, it will lead to commission of the crime, right? Or accomplishment. We have accomplished whatever we wanted, or it is the completed crime. Okay, so there are these 4 stages. Now, if you remember, I said that at the stage of intention, it's very difficult to prove that before the court, right? Because court would always rely on evidences that we present before the court. So at the stage of intention, it's all there in the mind of the criminal, right? We cannot go inside the mind of the person and read it. It's very difficult to prove that. Even at the stage of preparation, it's difficult, because we cannot just establish that whatever, if I'm buying poison, I bought poison to kill so and so person only, and I did not buy poison to kill the insects that are there in my house. It's very difficult, right? So same thing Supreme Court has also observed in various decisions. Okay, so Supreme Court has in many of the previous decisions already observed that nobody can enter into mind of the accused, right? Whatever he has done, whatever are the charges, we cannot read his mind. So his intentions has to be ascertained from what weapon was used, what part of body was targeted, and what is the nature of injury which was caused, because court relies only on the evidences available. And once something happens like this, we are just left with these evidences, like what weapon was used, to what extent the harm was caused, and which part of the body was targeted, right? So because we cannot read mind of the person, we can try to make some conclusions based on these points. And if we consider these points in this certain case also, here deadly weapon like a dagger was used, right? And the injury also was like the vital body part was targeted, which is stomach and chest. Plus injury was also very much severe. Now, considering all these 3 points, it does not look like an offense under section 323, which is voluntarily causing hurt. But rather, considering all these 3 situations, it's more appropriate to like attract section 307 of IPC, because the act itself was very much risky. The person could have died, right? But the person somehow survived, but still it would be considered as like a failed attempt to commit murder. It was just an attempt to commit murder and not section 323, because we considered all these 3 grounds. So Supreme Court also said that yes, trial court, whatever they had mentioned, that this person is held responsible or guilty under section 307, trial court's decision was also right. After that, High Court upheld validity of trial court's decision. So in this matter, High Court was also right in saying that, right? So Supreme Court upheld validity of the decisions which was given by trial court and High Court, and they said that this appeal which was filed, it is dismissed. So basically, Sadakat Kotwal was given the same punishment as which was given by trial court, and it was said that no, you are not guilty under section 323, rather section 507 is the right section under which you will be held responsible in this case. Okay, is it clear? Any doubts you have? All these 3 cases clear? Okay. All right, fine. So all these were 3 criminal appeals filed before the Supreme Court of India. where we mostly had provisions of IPC. Here and there we had Prevention of Corruption and Negotiable Instruments Act as well. Okay, so fine, then with this we'll end this class. If you are willing, you can go through these judgments as well from the website. Okay, thank you everyone.
Thank you, ma'am.
Thank you, ma'am.